This video we'll deal with interim orders. So interim order is a temporary order. So generally there are 8 types of interim order according to Takwani book, but it is not a hard say rule that there are only 8 types of interim orders. There are much more, but generally it is presumed that there are only 8 types. So first interim order is payment to the court. So it is given under order 24, and under this order, payment in court, this is a type of interim order that is given. And the situation is that where plaintiff has filed a suit directly to the court without even providing any notice to the defendant that the defendant has to pay him the money that he has lent. So without even providing notice to the defendant, he directly goes to the court and seeks for the money that he has lent. So in such case, what happens is that the defendant, without even hesitating, without causing any inconvenience or delay to the court, he pays the amount that has been demanded. So in such case, no cost will be applied to the defendant, right? So that is the scenario here. Before defendant deposits money or debt or damage, the full satisfaction of the plaintiff, then there will be no cost that will be imposed and suit will be abandoned. And notice be given to the defendant that the suit is instituted against the plaintiff, and there is no need to pay any interest on such sums as it is paid soon after it is demanded. The party to be blamed for litigation must pay cost to the litigation. Here, the defendant is paying the money as soon as he was asked to pay by the court. He is not causing any delay or putting forth any other claims that sometimes defendants may refuse to pay, saying that I didn't receive any money and stuff. So if they make such allegations that plaintiff is not being so honest here, or I didn't receive any money from the plaintiff, if they make such arguments, then it will cause delay to the court and will cause inconvenience. And in such case, at the end of the litigation, when the defendants fails to prove that they have actually did not receive any money from the plaintiff, then in such case defendant loses and the court will impose costs upon them. So basically the party to be blamed for the litigation, uh, the party that is responsible for continuation of litigation, rather making the suit as abandoned, rather abandoning the suit, the party which is responsible for proceeding the case, that party should be paying the cost. So the party to be blamed for litigation must pay the cost to the litigation. And Order 25 deals with security for the cost. So generally, an application is made by the defendant, or even the court takes it suo motu. When in the case where plaintiff residing outside India, or plaintiff has no sufficient immovable property apart from the suit property. So in these two cases, uh, the defendant may make an application like uh, the plaintiff is residing outside India, and the defendant is not convinced with the allegations that are put forth by the plaintiff. Like a plaintiff is making false allegation and he has filed the case. So in such case, when the court decides to put costs upon the plaintiff, so he will have to provide that cost, right? So just because there is a flight risk that when cost is imposed upon the plaintiff and he just flees away to another country, a security is demanded on part of the plaintiff, that the plaintiff has to provide some security so that there is no flee risk. If any cost that is imposed by the court, he that those costs will be met. even if he flees out of the country. So that is the general rule for this situation, that is Order 25. And not just these two grounds, the plaintiff must be residing outside India, and there is no reasonable probability not to be forthcoming. So there is no chance of him coming back to the country where he has sued the defendant, right? So on part of the plaintiff, when he does not provide any security, um, he will be given options, that is for the dismissal of the suit or option for withdrawal, right? Dismissal and withdrawal is two different things. So when it comes to absolute withdrawal, and there is one thing called qualified withdrawal. Qualified withdrawal, where it does not attract res judicata. So this qualified withdrawal will allow the plaintiff to file another case, and therefore it will not attract res judicata. So if any case that is dismissed by the court, such dismissal can be set aside by giving notice to the defendant, and why he is not providing security, right? So security has to be provided by the plaintiff. So that is the full essence of the situation itself, where the plaintiff has to provide some security, because flight risk is involved here. If he does not provide any security, that leads to dismissal of the suit itself, or option of withdrawal is given to the plaintiff. So such dismissal can be set aside by when notice is given to the defendant, and the plaintiff can also put forth his arguments as to why the security is not given, right? So such dismissal can only be set aside on these two crimes. And Order 26 deals with commissions. It should be read with section 75 and 70 to 78. This is third kind of interim order. Section 75 deals with uh, like a commission, when commission can be issued. So commission can be issued by an order upon an application made by both plaintiff and defendant. So one thing that should be remembered is commission, the application for issuing commission can be made on part of both plaintiff as well as defendant. So the purpose of issuing commission is to examine witnesses, those who are beyond local limit or about to leave local limit, or even person in government service when their attendance cannot be obtained, because their public service will be compromised when they are present inside the court, and the court don't want to waste their time as well. So the court doesn't want to compromise the public service, and so the court may appoint a commission and examine them. Those This applies only to persons in government service. So rule 4A talks about um, when even though witnesses are within the local limits, commission can be issued. So generally commission is issued when witnesses are beyond local limit, but there may be situations where even though witnesses are in local limits, there is a need for issuing commissions. So the commission can be issued on the grounds of interest of justice, for expeditious disposal, or for any other reasons the court may find, and issue a commission even though the witnesses are within the local limits. Uh, when they are not residing within India, the commission can be issued, and to take evidence, the commission uh, the evidence that has been received by the commission, those will be formed uh, a part of a record in the court, and not just examination of witnesses. The commissions can make local investigations as well. So, according to Rule 9, in order to obtain evidence, to elucidate any matter in the dispute, to ascertain market value of the property, to estimate mean profit, as well as damages and net profits, commissions can be issued. So, after investigations and collecting evidence, a report can be made by the commission and should be given to the court in writing. Commission can also be issued to adjust accounts, to make partitions, and to hold a scientific investigation, and to sell a movable property, to perform a ministerial act. So these things are included was included only since 1976 amendment. This could be an MCQ. So issuance of commission order is a judicial order, and issuance of such commissions have for that reasons also to be recorded. And under Rule 15, who will pay the expenses for such commission will be determined, where the party that is requesting for commission has to bear the expenses. So within Rule 16 to 18, powers of the commission is given. That is, they have power to summon parties, witnesses, and also examine them, and they can call for documents. They can enter into land, right? That is mentioned in the order only. Rule 18A deals with the commissions can also be applicable to execution of a order or a decree. So commissions are not only issued for sake of trial, but they can also be issued, and they will also be applicable in terms of execution of order or a decree. So Rule 19 to 22 deals with foreign tribunals. So when it comes to foreign tribunals, commissions can only be issued by the high courts. Order 38, Rule 1 to 4 deals with arrest before judgment on affidavit or otherwise. That is fourth interim order. So when defendant delays or avoid process of the court, so these are the two grounds in which arrest of the defendant can be done. When there will be delays, or there is a uh, there is a um intention upon the defendant to avoid the process of the court, or he obstruct or delays the execution of a decree. So in such case, defendant can be arrested, or when he leaves India, or he absconds jurisdiction, or is about to leave the country or that particular territorial jurisdiction, or he will dispose or remove property in unlawful way. So in these grounds, defendant arrest before the judgment itself, not even after judgment, but before the judgment itself, on affidavit, um, arrest can be done. So according to Rule 4, before arresting a defendant, so arrest can only be done when the security is not provided. So there is an option for the defendant to give security and uh, get released of himself. So when security is not furnished by the defendant, he will be arrested. So defendant in that case has to prove why he is not able to furnish security. Only then arrest can be done. So if he cannot deposit money or property, he can also give surety. If he cannot do all this, then he will be put into civil prison. So he can stay in civil prison until the decision of the court or decree is executed against him. So he can be put inside the civil prison only on failure of Rule 2 and Rule 3. That is, he is not providing any security, or he is not giving any surety, right? And there is a proviso: when such arrest is made on insufficient grounds, the plaintiff has to pay compensation that is not more than 50,000. So if he was arrested, right? So if he is arrested for insufficient grounds, the plaintiff has to provide compensation of rupees 50,000. This is one important factor, remember. And conditions of arrest before judgment would be: so plaintiff had filed the case in a bona fide intention and there is a cause of action involved, and there is a real danger of absconding or removing property of the defendant is involved, only then arrest can be done before the judgment. And order 38 deals with attachment before judgment. So order 38 1 to 5, rule 1 to 5 deals with arrest before judgment. Order 38 rule 5 to 30 deals with attachment before judgment, and this is a fifth kind of interim order. So where the same grounds, when the defendant is intended to obstruct or delay the execution or a decree, he can furnish a security. But if he fails to prove that why he cannot furnish security, the court may order uh, for him to give any property or its portion to be attached, right? So when he does not provide any security, the court may attach his property or any portion of his property to that extent. So it is a conditional order. Whenever such security is furnished by the defendant, he will be released. Mode of attachment will be same manner as provided the execution of a decree. So the effect of attachment would be the defendant will be restricted to alienate his property. So right to alienate his property will be snatched. If any claims attached to the property, it will be heard even before attachment, so that no third party is affected here via attachment. And the claims put forth that if any person has interest and claims over such property which is attached, then they will be heard even before attachment. Attachment order can be withdrawn when the suit is dismissed or when the security is paid. A fresh attachment of property is not required for the execution because you're already attaching the property even before pronouncing judgment. So there is no need of any fresh attachment that is required for execution. Agricultural produce cannot be attached. This is one important point to remember. So in Ramantek versus Solanki traders, uh, it is held that power under Order 38, Rule 5, is an extraordinary power and it should be used sparingly. And this power cannot be used to coerce, to threaten the defendant, and it cannot be used to convert an unsecured debt to a secured debt. So the effect of attachment would be the effect of attachment is not equal to conferring title to the plaintiff. No, it is not the case. So you're not conferring titles to the plaintiff here. You're just attaching the property. You're restricting generally the defendant not to use his power to alienate. So attachment is not equal to conferring title. If attachment was done on insufficient grounds, same year, 50,000 compensation must be paid by the plaintiff. And Order 39 deals with temporary injunction. Order 39, Rule 1 to 5. This is sixth kind of interim order. So, temporary injunction is that there are two types of temporary injunction. One is mandatory injunction and prohibitory injunction. Mandatory injunction, uh, we ask the defendant to do something, and in prohibitory injunction, the defendant is asked not to do something or to refrain from doing something, right? It is act in personam, that is when any injunction that is demanded by the plaintiff, that is acts in personam, because when injunction is granted, it applies only to the parties and not to third persons. So it only applies to the um, parties involved in the suit. Hence, it is not in rem. So there are other types of injunctions as well. That is temporary injunction, permanent injunction, prohibitory injunction, and mandatory injunction. Temporary injunction is that while suit is pending, asking for an injunction to be in effect for a time being enforced. So it is for a temporary nature. It is as simple as that. A permanent injunction is an injunction that will be in effect forever, right? It is usually given at the end of the litigation. Prohibitory injunction is asking the defendant to refrain, right? It is a refrain order, not to do something. And mandatory injunction is to do something. It is a command that is given by the court. And what are the grounds for granting injunction? That is given under section rule 1 and rule 2. So of order 39, rule 1 and rule 2 deals with the grounds for injunction. So grounds is when property of the suit is wasted or alienated or wrongfully sold. In such case, injunctions can be granted, or in the interest of justice, interest can be, injunction can be granted. And when the defendant is trying to remove or dispose his property, or he threatens to dispossess the plaintiff, where the plaintiff is having the possession. So in that case, the defendant threatens the plaintiff to vacate his property, and simply he dispossess the plaintiff with this property. So and is about to commit a breach of contract. So in these cases, injunctions can be granted by the court. And other important conditions, these are very, very important conditions. So the first condition for granting an injunction should be prima facie case. There should be a clear cut prima facie case before the court, and there should be a balance of convenience. So the court should determine who will be the most affected person, whether the defendant or the plaintiff, when injunction is granted. And there should be an irreparable injury. So injury that might be a result of providing an injunction, that particular injury cannot be compensated by money, right? So that will be an irreparable injury. And to irreparable injury, in the sense, the court will estimate to what extent that injury will be caused. An injunction is an equitable right, and it is the discretion of the court to give. The court may also refuse to give injunction, and it will be based on the conduct of the parties. If the court thinks of, or if it is on the opinion that the conduct of the parties are not good, the parties have approached the court in malafide intention, then the court may refuse to give injunction. An injunction will not be given when alternative or efficacious remedy is available. So when alternative remedy is there, the injunction will not be granted. And before granting injunction, notice for the opposite party must be given, right? But there is an exception for this. There is a concept called ex parte injunction. So it is an injunction as it sound. There will be no notice that will be given to the opposite party. So this type of injunction is granted when the objective of granting injunction will be defeated due to delay, when such notices are issued, or so delay will be caused when delay will be caused, and that delay is actually against the object of granting that injunction. So in such case, the court may grant ex parte injunction. But while giving or granting ex parte injunction, the court will record the reasons to that effect. And in Morgan Stanley Mutual Fund versus Karthik Das, so in this case, it was held that while the party that is applying for ex parte injunction, they have to uh, send application, affidavit, plaint, and document that has been relied in order to grant that injunction, that should be sent to the other party against whom such injunction, ex parte injunction, is passed. Because generally in ex parte injunction, the defendant is not given notice, so it is a step to provide a defendant with notice at least after granting such injunction. So the court should also record the files that have been sent to the other party. And section 94 clause C and order 39 or rule 2a, it talks about arrest or attachment when any breach of such injunction uh, has been uh, has been occurred. And granting or refusing injunction is subject to appeal. So when any injunction is granted, it is subject to appeal, revision, right? And even writ petitions under Article 226 and 227 can be filed, or the parties may also approach the Supreme Court via special writ petition, that is Article 136. So another one is another type of interim order is interlocutory orders, that is provided under Order 39, Rule 6 to 10. So interlocutory orders are generally granted for selling perishable property, because the property that is perishable in nature can be cannot be kept uh, for long terms. Like they will be their nature is that the court cannot have such property for longer periods. So the court may order for selling such perishable property. And according to Rule 7, the court may also authorize any person to take samples or make observations, or uh, trying to make any experiments for even for that person purpose. Interlocutory orders can be granted by the court. So before the court issues such orders, the notice must be given to opposite person, right? That is provided under Rule 8. And Rule 9 deals with it is a big provision that is given in the Bar Act, but it simply talks about it is an order where uh, it is of such nature where uh, plaintiff is asking for the possession. Like if any person who's paying tax to the government, he should be vested with the possession, right? So it is that sort of order where which puts the person paying tax to the government with possession. So during the litigation is pending, but putting the person who's paying tax with a possession will not mean that there is a transfer of ownership. For time being, till the period of litigation is there, he will be vested with such possession because he is paying tax to the government. So according to Rule 10, person who is holding money and is calling himself as a trustee and misusing funds of a particular trust, so in such case the court may order to deposit such amount on the court. So these are some type of interlocutory orders. And order 40 deals with receiver. So when the court is of the opinion that both the parties to the suit must not hold the property, so in such case receiver can be appointed by the court. So the sole purpose of appointing receiver is to uh, preserve the property, as well as the fund is involved in the case. So it is a very harsh remedy because the court does not believe in both the parties. and it is the discretion of the court to give this to appoint a receiver. The court can appoint a receiver before a decree or even after decree. The court may appoint a receiver, as the court will fix the remuneration, uh, and will be fixed via general or special orders that will be issued by the court. And the power of the receivers would be, the receiver can file a suit that is relating to that property to which he is entrusted with, and the receiver collects the rents profits arising out of such property, and the receiver manages and protects and makes improvement to that property, and he executes any document, for example mortgage document. He can he can execute such documents as well for the benefit of the owner as well as the property. And what are the duties of receiver? Here, duties of receiver in the sense the receiver should furnish security, because after all, human being, he cannot be trusted, and the court will not trust anybody. So even the receiver should furnish security, and he submits accounts as well. The receiver submits accounts, if any, that is involved and in the case, and uh, if any amount is due on part of the receiver to pay to the court, he must pay, right? So he should pay amounts due from him, and he is responsible for the loss that is arising due to his willful default and negligence. So while the receiver is entrusted with the property, if he due to his act, any negligence that has been caused, and due to such negligence there has been some losses, due to his negligence or his willful default, there are some losses, then in such case he will be responsible for that. So if he fails to comply with these duties, he will be personally liable. So even receiver's property can be attached. His private property can be attached when he fails to comply with all these duties. So rule 5 deals with consent of the collector. So the court may appoint a collector upon his consent as a receiver for a land that is paying revenue to the government. So while appointing a receiver, the court it is not required for the court to furnish any notice or preliminary notice to any parties to the suit, because the court is, after all, is not believing both the parties here, and the court is uh, appointing receiver here without believing both the plaintiff as well as defendant. So there is no need to provide any notice. But at the final order, both plaintiff and defendant will show up, and they will be heard. The receiver is appointed for fixed period. So the receiver is not appointed for a perpetual memory. He is appointed only for a fixed period, and it is not a hereditary post. It is not that if a receiver is appointed, his son will be appointed as a receiver to that property as well. No, it is not the case. So receiver is not a it is not a hereditary post, the receiver post, and such uh, appointment of receiver is appealable and revisable, and even writs can be issued upon the receiver's appointment order. And receiver appointment of receiver is generally opted for in medio property, which means the property is not enjoyed by anyone currently. So the properties of for the properties of such nature, receivers are generally appointed, and that is all about interim orders under CPC.